Welcome to the monthly Truck Stop webinars brought to you by the Motor Carriers Insurance Education Foundation. These truck stops are presented the second Thursday of each month at 11:30 a.m. Eastern Time. These webinars are presented as industry updates for informational purposes only and do not qualify for state CE credit. The foundation offers numbers of other opportunities for CE credits to meet your state licensing requirements. Please contact our office if you need more information about these particular programs that meet the CE requirements. If you have questions, please type them in the chat window. They will be answered or responded to after the webinar via email. If you experience any audio problems, please send us a note in the chat window or call 800-741-484. We will attempt to correct the problems as soon as possible. Update. The following session was previously recorded with Fred and I to make it available to edit and present here for our time frame. But at the beginning of 2023, FMCSA published a notice of proposed rulemaking that addressed a lot of the situations that Fred and I are going to talk about later in this seminar. So I want to give you an update on this notice of proposed rulemaking. Trucking information headline: FMCSA goes after unscrupulous brokers with the proposed rules. What they're trying to do is to make sure the trucker gets paid for the loads they haul from that were arranged from a broker when the broker doesn't pay them. This rule was required in the 2012 MAP 21, Moving Ahead in Progress in the 21st Century. So this is a real old requirement. It was just never addressed until now. The FMCSA will take comments on this notice of potential rulemaking until March 6, 2023. So anyone listening from the insurance area here who wants to go into the website, FMCSA's website, and make comments concerning this rule, we strongly suggest you do that. This is your opportunity to express this. Besides the questions of brokers and freight forwarders definition that Fred and I will be talking about after I finish this update, the other things are added to this. Assist assets reality availability. It requires a trust fund for payables to truckers. This is that bond that you're familiar with, $75,000. That bond is just a payment bond. It's there for the motor carrier to access if the broker does not pay the motor carrier. In addition to requiring this, and then now addressing who's going to have to require this as we move forward, going back to the definitions, the other provisions you add is immediately suspension the broker, freight forward, or operator if the bond funds on hand fall below the $75,000 requirement. This can happen when any claim makes, because these bonds are a aggregate amount of $75,000, not a per occurrence for $75,000. So once a bonding company makes one payment, unless they have an arrangement with a trucker to secure, with a broker to secure that or have other security, that they could not now meet this requirement, and they must notify the government about now no longer honoring that $75,000. This is going to be a big situation between the bonding company and the broker to make sure this does not happen. So, security and trust responsibility, notification by the bonding company of any bankruptcies or insolvencies of one of their clients who they're providing a bond to. This requires an immediate notice of the FMCSA. And then lastly, the enforcement of the authority. It set up notice requirements as well as penalties for violations. The notice requirement was always there, but nobody ever enforced it. Now they're talking about enforcing it, but they're doing one other thing that's addressing in this rulemaking is now they're going to be able to penalize and fine the broker for violations of the MAP 21 rules. So this is really the update here. What is brokerage and how it affects a trucker? Presented by Fred and Marcinak, Moseley, Marcinak Law Firm in, I guess, Greenville, South Carolina. Fred, although I think you're a teller, are you not down the street from that?
Well, that's the world headquarters is in Greenville. But yeah, we are privileged to work with truckers and brokers nationwide on a variety of things. And the issue we're looking at today is a nationwide issue. But yes, we are out of Greenville, South Carolina.
And good friends of the foundation have contributed often to stuff, and people that we refer to if they have concern not only about this, but other things involving truckers. And of course, I'm Tommy Ruke, Educational Director, MCIEF, and Fred put some good stuff here together and going to walk through these slides. And then we'll talk about the things that really affect the insurance part of it once we get through the technical part. Fred, this is something that the government just sent out, a interpretation of what brokerage is. Is that not what I read in a hearing on Road Dog Radio Show things? And so this is what we're looking at today.
That's true. And, you know, this has been a 10-year process. We're going to talk a little bit about that. But really, this comes out of treating brokers different from truckers, understanding that they're different. They look different. They talk different. They operate differently, and trying to figure out who's a trucker and who's a broker, and make sure there's a clear distinction. And so we've got some new interpretations from the government that are supposed to help us be able to do that a little better.
But they're from the government, so beware.
This Take it for what it's worth. That's right.
Go ahead, Fred.
Yes. So this is, I mean, this is the definition. This is the law. This is in the statute that Congress passed. That a broker is someone who, and there's a lot of words in there, but basically arranges for transportation is the common thing we talk about. So it talks about selling, providing, soliciting, advertising, but the real key phrase is a broker is someone who arranges for transportation. So they don't perform the transportation. You can see there it says other than a motor carrier, so they're not doing the transportation, but they're arranging for the transportation. And so that's what the law tells us a broker is. But how do we define that? It's difficult to define. Over the years, we've seen things like convenience interlining. So a motor carrier says, I'm going to engage in convenience interlining. I'm going to take freight from a customer. I can't transport it. I don't have the volume. I don't have the equipment, but I'm going to interline it to another carrier, and I'm going to call it interlining. Or I'm going to subcontract it. I'm going to subcontract out my carrier work to another carrier. Or I'm just going to dispatch this to another carrier. Well, are those things brokerage or not? And those have been difficult things over the years. So we're going to talk about that today, whether those things count as brokerage.
And the problem is, if they count as brokerage and they've done it, then there's some penalties we're going to talk about later. This is why this is so important. And this was actually probably more relevant last year when the trucking industry did not have enough capacity and people were getting opportunity to haul loads they couldn't do themselves. They were letting other people haul loads. It's kind of slowed down a little bit, Fred, but this is where they get a load and they want to get something out of it and they give it to a friend. All this needs to be done, and obviously people used to trip lease call that part of it, which you don't do much anymore. I haven't seen any trip leasing in a long time, but this is how you would do it formally. If you wanted someone to haul a load, you accept it, and that's lease them and put your DOT number on the side and the bill of lading there. This is not what's being done here. They just call up and say, I got this load, do you want to haul it? And they haul it, and then the first trucker accepts it, then accepts the money in most cases and handles that way. Is this not what we're talking about in these areas?
Yeah, I mean, trip leasing is still legal. It's still allowable, and it's not brokerage because it's moving under the assigned carrier's authority. So that's still a thing. It doesn't happen much, but that's still allowable. But these things we're talking about here, this kind of subcontracting, convenience interlining, before MAP 21, but before that that came about 10 years ago, these things were I would say commonly accepted in the trucking industry as not being brokerage. But of course, the brokers didn't like that because they said this is brokerage, and you're doing it without having to have a bond, without having to have broker authority. You're kind of doing it under the radar. And so MAP 21 really was intended to crack down on these practices, and to say, you know, we're gonna define these things as brokerage and cut down on it unless you have broker authority. And so that's really where that came from, and that was really the start of all of these discussions.
Folks, you might have heard MAP 21, and I just revisited Fred in our CONT today back in 2012 when it was, but it did a number of things. That's where it mandated ELDs. That's where it changed to the restart for 34 hours, noon and not. This is where they started mandated the drug testing, they mandated the entry-level driver training, and other things, as well as the brokerage. We only focus on about, what, 3 pages or 3 paragraphs of a 200-page law here, but that put a lot of things in motion that we are seeing here. This is the one that's still with us that comes up all the time. So when you hear referring to MAP 21, we're referring to a part of MAP 21 that Fred says that tried to put this. And this was done, I understand, Fred, a lot of brokers were involved in this because, and shippers were involved in it because a lot of times these less than qualified brokers were taking the money and not paying the trucker, and the trucker's coming back to that shipper and say, I did the service, pay me. And then they had to pay twice because they already paid the brokers. I think that was a part of this to get enough legislative emphasis to put this regulation in place.
Yeah, and that's right. And so the shippers pushing for it because, as you said, that under the law there was an opening for the carriers to seek a double payment from the shippers in that situation, and also the brokers. The TIA folks, the brokers were pushing for it because they're saying we have to buy the $75,000 bond if you're doing these things. And MAP 21 changed it to 75,000, and so that was kind of a trade-off. Was if you're going to make us, that was actually part of that compromise, Tommy, was the brokers said, if you're going to make us have a higher bond, if we have to go out and spend more money to buy a $75,000 bond, then you, Congress, have to crack down on these folks that are brokering without even buying the bond at all. So if we have to pay more, then you've got to stop the guys who are brokering for free, essentially. And that was kind of the compromise that was put in place in that law.
Right.
Yeah, here's the regulations, and we don't have to read through all of these in detail, but I put these in just to show you how brokering is different from trucking. Brokering, there are specific requirements for brokers that make you different from truckers. You can see here at the bottom of the screen, experience and training requirements. There are those requirements for brokering, and so there's a separate process you go through to get licensed as a broker as opposed to a trucker. You have to comply with these regulations, and so that's part of it. Is it looks different from trucking.
And then we talk about the bond. Fred, I ask this almost every class about, do you know what that bond is? And unfortunately, agents don't understand what that bond is. It's a payment bond. I ask them what it applies to. They think about liability or cargo. It's nothing else. It's only when the broker does not pay the motor carrier for hauling the load is that bond then being able to call upon. That's all it is a payment bond. I sure wish the government guaranteed payments of my premium or things that I generate. I'm sure you would love the government to guarantee your customers to have a bond to make sure that they pay you for your services. But that's all this is a payment bond.
That's right. And yeah, so we need to understand that. And then, if you ever filed a claim on a bond, I've done that for a lot of carriers over the years who have not been paid by a broker. If you file a claim on a bond, you find out that it's actually not even maybe as broad as you think it is, in that the companies who write these bonds, they know the law very well, and they will tell you, okay, if this shipment was an intrastate shipment, it's not covered by the bond. If this shipment was exempt freight, it's not covered by the bond. If this shipment, if you carrier were not listed on the BOL as the carrier of record, we're probably not going to pay that under the bond. If this broker owes more than $75,000, we're going to prorate that, so you may only get back pennies on the dollar for what you're owed. So that's what it's there for, but you got to be very careful when you claim on it to do it the right way to make sure you can get paid.
When this came out in 2012, because it was so hard to get a 10,000 bond, we did have an arrangement, and I have it set up here, where we had a bonding company. Hank Seaton and I had put this together with a company that Jim Harrison, friends of mine, put together out of Miami, that actually wrote bonds for brokers that we referred our members to. It's still available to them, but I think it weathered down some. It's not so hard to get at first, but we try to get a facility first because this was a big thing. The 10,000 was hard to get. 75,000 is 7 times as much. So anticipation of that. And you're right. There's ways to not enforce that, because nobody wants to pay unless they have to. and the trucker thinks it's a backstop. But the problem is, though, later what we have, if it's legitimate, later using these other services we're going to talk about, if it's not brokerage authority, then they don't have that protection. So this is a consequence. At least this is there for a legitimate load that is legitimate brokered if they don't get paid.
Sure. Yeah, and here's where we get into some other things that we've already kind of talked about a little bit. This is part of this law that's on the screen now is part of what came about that was kind of beefed up in the MAP 21 process. But it's illegal to broker without broker authority, and so the law says that, and that's the law. And so as a trucker, if you're doing things like convenience interlining, subcontracting, that's going to be considered brokerage, and it's going to be against the law unless you have broker authority. And so, you know, Tommy, one of the things you and I've talked about is that's the law, but before MAP 21, there really was no teeth to it. And so what the brokers tried to do in MAP 21, as we said, is if you're going to make us have a higher bond, you've got to enforce this illegal brokerage and keep people from doing it. And so we've got some new penalties that are on the screen here that were passed as part of MAP 21. And so let's just talk a little bit about enforcement. If you were to say to me, well, you know, I'm a trucker, and sometimes I just have to interline or to subcontract because I don't have the volume, and I just have to do it, and I don't have broker authority, and it is what it is. I have to do that from time to time. But is there really any danger there? Am I really at risk if I do that? And I would say two things, Tommy, as you and I have talked about. First of all, as far as government enforcement, that has not really happened at this point, because the FMCSA, who's charged with enforcing this, they're focused on safety, and they're focused on using their resources on carriers. And so they really have not put resources into policing illegal brokerage. So we haven't seen any government enforcement. It remains to be seen if that will increase, but we haven't really seen that. But the second thing on the screen here, that part D at the bottom, the liability for civil penalties and for claims, this can be enforced by private parties. They can file a lawsuit against you, and if you see there at the bottom of the screen, they can sue the corporate entity involved, but also the individual officers, directors, and principals of such entities. So if you broker freight without authority, and maybe there's a dispute with the carrier you broker to on payment, or maybe there's a dispute on some cargo damage, as to how that shakes out, or maybe there's some dispute that comes out of that. I've seen it mainly in payment disputes where carriers didn't get paid by the illegal brokering company. They will sue the individual officers, directors, and principals. So if you're a carrier and you're brokering, you're subcontracting, whatever you call it, without broker authority, the individual owners of that carrier company, they could have a lawsuit against them personally. That's what this law says. And I have seen those lawsuits and participated in them. So that's a real enforcement mechanism that's out there.
Fred, and this is scary. I want to just step back to when he's talking about it. He's not really talking about someone who puts themselves out as a broker. He's talking about maybe an agent or a trucker with two trucks, and they get a call from a broker that says, or a shipper, I got a load to be hauled. Do you want to haul it? And they don't have a truck, and they send somebody else there to pick up that load instead of them taking it, and then they take that down the road. Actually, I was involved in a case, and this was a big case. This was a liability case. A trucker out of Florida accepted a load from our friend C.H. Robinson and then gave it to a second trucker who had an accident in New Mexico that had some damage done. And the plaintiffs in New Mexico not only sued that trucker, but they tried to bring the first trucker in by saying you violated MAP 21, and they put in that complaint a civil penalty. Conspiracy for avoiding MAP 21 is a part of the complaint. And so they were trying to bring the first one in who had nothing to do with the crash into this claim using these kind of provisions here. And it was a strange part about it, and this was probably 7 or 8 years ago, because the insurance company did not understand this, that they did refer the lawyer to me, and Fred, the lawyer didn't understand this part of it, what they were trying to do. I fortunately knew enough about it, and just sheer unadulterated luck, they were hauling beans. beans are exempt. So as you pointed out, beans are not subject to this regulation. So I wrote an opinion and I got them out of the case. But that's sheer unadulterated luck that happened in this stuff.
Yeah.
But a lot, it's not known. And the problem we have on that first trucker is that when they accept the load, if that policy has non-owned auto coverage on it, and we give hired non-owned all the time, we have non-owned auto coverage, then that load by that second trucker where they got named in the suit is covered under non-owned auto coverage on that policy, because it's an auto the insurer didn't own, lease, rent, or borrow that was being used for their business. We all think about non-owned auto coverage being personal autos, but in this case, that's what that coverage was. And this is why there was coverage on that, back on that first trucker and the policy itself. And this is why the insurance company, but that's a real example, Fred. And,
Right.
and so this is why we got to talk to our insurers. Don't do this, basically.
Yeah, and by the same token, if that had been a if they had a scheduled auto policy, and I've been involved in this case too, if you have a scheduled auto policy, and so this load is not covered because there's not an insured auto involved in this transportation. Also, there's law that says the MCS 90 isn't required to respond in that situation because the first motor carrier is not operating as a for-hire carrier at the time of that loss, because only the second carrier is actually operating as a for-hire carrier. So you have no coverage, you have no MCS 90, and now you as a trucker are faced with defending that case and potentially paying it out of your own pocket. So
that's great with special auto. I just also want to point out there's more danger in non-owned auto than we think, Fred, is what I was trying to point out there, because now shippers are requiring at least hired, and we usually just conveniently roll in hired and non-owned at one coverage. But this is an exposure that non-owned basically has a lot of teeth in here for these very rare situations that we don't think about. We understand what hired is when you go hire an independent contractor or hire a truck, but we don't think about the non-owned pertaining to this. And I talked to ISO, they don't have a rate for that. They don't have any ability to even collect premium for it because non-owned auto is based on number of employees, not even this coverage. But this is where I thought this is where, but I agree with it. Specified, they're back to losing their company on this part of it.
Mm-hmm. Mm-hmm. Yeah, and here's more regulations on brokers. You know, what we're trying to say here is they're different from motor carriers. They're special regulations they have to comply with. If you're we talked about that situation Tommy just described where you take a load and you don't have a truck for it, so you so-called subcontract it out, which is really brokering it without broker authority. This regulation says you have to keep the money you receive from that load separate from your carrier funds, and you have to hold it aside to pay to the carrier. So you're violating that regulation. So different regulations to comply with. Brokers sometimes, and we're getting into other things that show up under brokers, but brokers sometimes show up under, California finds a way to get everybody, Tommy. They find a way to get into your pocket. And here there were two brokers who were fined for, everybody's probably heard about CARB, certain air emission requirements that you're required to comply with in California. We know trucking companies have to do that, but here the board out there fined two brokers for so-called dispatching non-compliant trucks. So, if you're that carrier and you illegally broker, you subcontract to another carrier and they're non-CARB compliant, here's another way you could get in trouble with California is on the CARB requirements. So more problems there.
Even if you're a broker here, and I thought, Fred, one of these was not even the truck; it was the refrigeration unit.
Reefer unit. That's right.
On one of them, not even the truck itself, without doing it. So,
right.
I mean, this would be interesting for both the broker and the trucker in that case, because the broker would be liable as well as the trucker's liable.
Exactly. Yep. And brokers have different insurance, and Tommy will probably want to add some detail to this, but the point of this slide is to say if you're a carrier and you are doing that interlining, you're doing that subcontracting, and you which under the law is going to be illegal brokering, you're not going to have the right insurance in place to cover your broker operations. And so here's some of the insurance that brokers typically have that you as a carrier may not have.
Yeah, and the reason you don't have is most cargo policies say three things. It's in your care custom control or in your care control, or you're legally liable for it. Well, if you don't have it, you're not any of those things. So, and a lot of them have an exclusion. If the bill of lading's not in your name, you don't have any coverage for it. So the standard auto policy doesn't cover, cargo policy doesn't do that. Contingency is what brokers buy in case there's not enough coverage. And we don't want to get into this right now because contingency would be, depending on the marketplace, there's two types. One, just to replace what should have been there, but one to protect the broker no matter what the claim was. So there's other things. It is available marketplace. A lot of truckers do not have CGL. If they do have CGL coverage, then CGL policy, if it's not excluded, Fred, as you know, covers not on auto in that exclusion G, so that you could get some auto liability coverage there, as you point out here. And then you don't have the broker bond again, so you could be liable for the money that you got from the broker. These are the lack of coverage of a trucker who's illegally or not conforming to the law. Let's don't say illegally, part of that. They're not going to get handcuffed on it, but could be subject to these penalties and fines because, and the liability because they violated the law.
Yeah, and we've already talked about most of this. Next slide, the changes
Right.
that MAP 21 brought about. We've covered that, but there's a summary of it. And I'll just point out on this first bullet point here, we talked about the personal liability, which is the second one, but the first one, we talk about interlining. Yeah, so the top bullet point on this slide, convenience interlining is what I call where we talked about you have two trucks that are in service, but you take a load from a customer and you just immediately send it on to another carrier for them to transport. That's convenience interlining. That is brokering under the law, and you'd have to have broker authority. True interlining, where one carrier actually touches the freight, that's still allowed without broker authority. So that's what we're used to in the old days of regulation, where truckers were regulated for certain lanes. If carrier A actually physically touches the freight and then hands it off to carrier B to engage in further transportation, that's still allowed without broker authority. That's true interlining, and you can do that. And a lot of times that happens with LTL carriers. They will they have what they call purchase transportation for over-the-road lanes. They also have local delivery companies they work with in cities. That's allowed. That's all true interlining. And now you still have to think about some insurance issues and some exposures when you hand freight off to another carrier. But that's not brokering, and that is allowed.
Yeah, I did that part. They touch it and they move it. And freight forwarders also are not subject to this either because they take possession if they have freight forward authority. But most of the truckers do not have either one of those things. And again, remind them of their potential liability. MAP 21 just got rid of about 40% of the brokers here because they couldn't afford the bonds and this kind. But as you said, what I thought, Fred, and this, that when you read the statute and all, it says if you have been violated, meaning the shipper, type it in the chat window and we'll get to it when we can. I think that was what was built in there. There's just no enforcement we talked about other than the court systems, and which is major concern of the insured. This is why a lot of this is not found out until something happens, payment not made or crash happens or cargo not being paid. So we don't see enough of this where there is really enforcement. It's just when something that we point out happens.
Right.
So let's look at the guidance now.
Yeah. So that's Tommy. We've been talking for what 20 minutes now, but that's all background for the new guidance that's come out. So where do you draw the line between broker and non-brokering? And we talked a lot about the interlining and the subcontracting, and that's pretty clear. But now you have these services like dispatch services who work for more than one carrier, and they're dispatching trucks from multiple carriers, or you have people who describe themselves as agents, and they're working for multiple carriers at the same time. Where, and are you a broker when you do that or not? If you're pulling from a pool of carriers that you say you dispatch for, and you're kind of picking one and assigning a load to it, isn't that brokering? And that's what the government's trying to figure out with this interim guidance. Now, point out a couple of things. The interim guidance does not have the force of law. It is interim until the final guidance is written. So what this is it's kind of a sneak peek for the FMCSA to say, this is where we're heading. This is what we're looking at. Provide us comments, and then we're going to turn this into law at some point soon. So but that's what we have now in this interim guidance, is how we separate true brokers from these agents and these dispatch services. So thankfully, the government has not said all agents and dispatch services are brokers, period, across the board. You can't do it. They've said we're going to look at, at some details about whether you're operating as a broker or not.
The thing though that we won't go back is that first definition on slide 6. They were arranging loads. So this is why there's a question that we get here, because they were arranging loads, what they were doing. We also mentioned this regulation is not for fresh fruit and vegetables, not for cucumbers, going back to my father, but only when he's hauling or arranging loads for pickles. This is the thing we get. So any of the agriculture haulers out of Florida, California, and fortunately that bean hauler out of New Mexico was not involved in hauling regulated commodities. So exempt commodities do not apply to this either.
Right. And yeah, on that, just briefly on exempt commodities, we've talked about that. There is as with anything with the government, Tommy, there's a list of, dozens, if not over 100 things that are considered exempt, and sometimes it's arbitrary. You mentioned cucumbers are exempt, pickles are not. You mentioned certain types of Christmas trees are exempt, others are not. It's a kind of an arbitrary thing, but basically what it comes down to is fresh produce or product, farm to market is what I always say, farm to market type exemption. It's a holdover from the days of regulation that we still live with today. But that's what we mean when we talk about exempt.
You can find that in the Motor Carriers Act of 80, but the two examples I use, Fred, is bananas are regulated because they're not supposedly domestic, where cucumbers are not. The other thing is that cut up chicken's not regulated, but cut up cows is. So their size makes a difference. So, you
That's
have
right.
these.
That's right.
Part of it, but you never know. But
yeah.
It's grown from the field is where we basically talk about, or it's live and was raised on the field and not been done,
right.
Except for chickens. Go ahead and talk about this. Is
Yeah.
the bona fide. This is where a trucker hires supposedly somebody to help them get loads. I guess is what this definition, right, Fred, or what we're talking about.
So I'm a trucking company. I'm looking to really expand my my business, and so I hire an agent who's going to go out there and try to get business for me, try to get loads for me. Obviously, a lot of trucking companies have dedicated sales personnel who work for them and for them only, and that's fine. Those folks are not going to be brokering because they are working exclusively for one trucking company just to go out and get business. That's allowed because that would be considered an employee of the motor carrier. And you remember way back on the definition, a motor carrier and their employees are not brokers. So that would be okay. But here where we're dealing with, you can see the definition, persons who perform duties for the motor carrier but they are working for more than one motor carrier, or at least they can send freight to multiple motor carriers. So I hire, Joe Smith to be my agent, and he's gonna try to get freight for me, but he's also an agent for a dozen other motor carriers and trying to get freight for them. Is that brokering or not? And that is what we're dealing with here. And so some groups here, we're pushing for the government to say, if you are an agent for more than one motor carrier, then you're a broker. If you represent more than one motor carrier, you're functioning like a broker because you're taking freight and assigning it out to different motor carriers, and that's what brokers do. And so they were pushing the agency to say that, but the agency didn't say that. They said representing more than one carrier does not necessarily mean that you are a broker rather than an agent. They also said that handling the money between, so if I'm an agent and I go out and find you freight as a motor carrier, but you pay me just a flat rate to do that, you compensate me in some way other than me taking a margin out of that freight rate, then I would argue I'm not a broker because I'm not taking a margin. Well, here the agency said that handling money, that would strongly suggest that you're a broker. If essentially, if the shipper pays the agent and then the agent pays the carrier, the funds flow through the agent, and typically the agent takes a cut of that. They said that looks a lot like a broker, but it doesn't necessarily get you there 100%. We're going to look at other things too. And so kind of the catch-all on the third bullet point, any determination will be highly fact-specific and determine whether the person is allocating freight between motor carriers. So what they're saying there is, if you are working for more than one motor carrier, if you're handling the money and taking a cut of that, and if you're deciding, if I've got 10 carriers and I'm deciding which one of those gets the freight, then I'm probably going to be a broker if I'm doing all those things.
And again, they point out the middle paragraph here is because now they're not subject to that bond, and that's the bond to have some protection for the shipper and the broker. So that would be the distinguished part, that you do not, the handling money makes you more, because now you're more liable for those funds you have that needs to get to the truckers, and you get back to the MAP 21 requirement there, Fred. I think that's why they carved that second paragraph that we have up here out.
Right, and then we get to dispatch services, which are kind of like agents, but a little bit different. But they work. They don't have any setup with the shippers. Is the difference? So an agent may have some connection with a shipper, but the dispatch services, they work exclusively for motor carriers. They go out and source loads. They perform additional services. So in addition to just sourcing loads, they're probably going to be engaged in managing that load and talking to the driver in dealing with operational issues that come up while the load's moving. So they're like agents, but they're a little bit different. You know, we kind of know that, you know, if you're a motor carrier and you have a sales agent that goes out and finds freight for you, they generally aren't dispatching that freight. You've got a dispatcher who's doing that, and that's kind of the difference here. Here the agency said, and you see the second bullet point, this is the important one, when they don't participate in the arrangement of freight, so they're not going out and sourcing the freight, all they're doing is dispatching, or when they represent only one motor carrier. So even if they are arranging the freight, they're sourcing it, but they're only doing it for one motor carrier, then they're not a broker. And so that's a clear definitional line there. But if they are allocating freight between different motor carriers, that's when we get into them possibly being brokers. And so these are the factors for dispatch services. There's 6 of them here. We don't have to go through all of those one by one, but you can see if you read these factors, you know, they interact with the shipper. They take compensation. Here we talk about that margin. Number 3, they arrange for the shipment, and there's no contract between the carrier and the shipper that's already in place, but they're arranging for it. They accept a shipment from a shipper, then go out and try to find a carrier to move that. So if they're going out and saying to a bunch of different carriers, I need quotes for this lane. The fourth one is if their name's the party on the shipping contract. So if the dispatch service is contracting with the shipper, not the motor carrier. If the sixth one, if they're soliciting the open market for carriers, means they're saying I need rates for this lane, I'm going out and I'm soliciting rates, then those are all things that look a lot like brokerage and are probably going to make you a broker.
Yeah, and this, we're talking a minute about all the new load boards and all, but this is a concern that you have. And just so circle back again, Fred, what happened is the MAP 21 put some burdens on somebody to be a broker. You got to do the training, you got a $75,000 bond, which means some insurance company or some bonding company underwrites your financial worth before they'll issue it, which leaves the 40% of them out. So what they try to figure out is a way around it. Part of it, I think, Fred, this is where we are here. And now the government's saying, again, we can't enforce it, but here's where we give some guidance to these offshoots that are still arranging loads. Because as you pointed out, a trucking company can as a sales agent. That there's no there. I think a dispatch service comes closer to a broker than a sales agent does, as far as that goes.
And in a dispatch, if a dispatch service, as we said in the prior slide, if all they're doing is dispatching, they're just involved at an operational level, they're not sourcing the freight at all, then clearly they're not a broker. But when they start doing that sourcing, yes, you're exactly right. That's when they start looking like a broker. And it's not only the government that's pushing this, but it's the legitimate brokers. So it's the TIA members who are saying it's unfair if we compete with folks who don't have to comply with the same requirements we do. And so that's part of the push here. And this interim guidance, there was actually language in the transportation bill last year that Congress passed that required this. So this is coming from Congress, which means it's coming from TIA and the broker lobby. They're the ones pushing for this.
And I imagine some shippers too who are getting caught in the middle of this part of it. And the key part here, you get back to it. All loads are generated by a bill of lading or a receipt here. And part of this is if the motor carrier's name that's hauling a load is not on that, then there could be a problem with all these, right, Fred? I mean, when you boil down to actually the crash that had happened, whose name, who accepted that load? And if you have the dispatch service or the designated agent, that part of it, I think that's where you're going to get some problems. What do you think?
Yep, I agree. And yep, and not only we've talked about insurance gaps, we've talked about personal injury liability, we've talked about cargo, but also, of course, when you have that mismatch in the name on the bill of lading, that's where you get these fraudulent brokerage situations where somebody steals the freight charges, and then there's the actual carrier going back to sue the shipper. So yeah, that causes all kinds of problems. Okay, we talked here about the $10,000 civil penalties. I think we've covered that, but that is a consequence here.
But it's not enforced.
Not enforced.
Let's talk about these load boards. How do they fit in here? And I guess the load board. Explain the load board, Fred, to the agents here that might not understand what a load board is.
Yeah, this is important for the audience to know, because load boards are huge. Especially with smallish to medium-sized carriers. So load boards are a source of freight for most of your small carriers. So there are hundreds, if not thousands, of carriers that operate 100% exclusively off load boards. All they do is take freight off load boards. And so a load board is I'm just going to use the word website, but it's a technology platform. It's a website where brokers or even shippers, but it's mostly brokers, can post loads. So I've got a load of X freight. I've got 10 pallets of whatever freight that needs to move from Columbus, Ohio to Little Rock, Arkansas. And I need a carrier to move that load for me on that lane, and carriers can go in and access that and can bid on that lane. They can go in and bid and put their rates in and get the business and pick up that freight. Then they send the truck to Columbus, pick it up, and move it to Little Rock. And so that's how a load board works. And there are carriers that 100% of what they do is source freight off load boards. There are also carriers that are maybe a little bit bigger who have dedicated customers that they're moving freight for, but are using load boards for their backhauls. So I'm moving customer freight from Columbus to Little Rock. I've got a customer in Columbus. I'm picking up their freight, moving it to Little Rock. But now I've got a truck in Little Rock. I've got to get back to Columbus. And I'd rather that be a revenue move than a deadhead. And so I'm going to use a load board to find a load that maybe it's not in Little Rock, maybe it's in Fayetteville, Arkansas, but I can send the truck over there and pick it up. And maybe it's not going to Columbus, maybe it's going to Cincinnati, but at least it gets me most of the way back with revenue. And so that's what load boards do. And so the question here is that brokering? And the bottom bullet point here, technology platforms, I put that in because load boards are traditional, and I just think of it like a website. Technology platforms, now there are apps that you just have on your phone, on your tablet, that where shippers and carriers can just connect and negotiate for the movement of freight. So the question is that brokering? Are the load boards, are the technology platforms engaged in brokering? Are they arranging for transportation of freight? And I'll give you my opinion on that. My opinion on that is that if they do it right, they're not engaged in brokering. If they are simply letting a shipper or a broker, a customer, someone who has freight that needs it moved, whether they're a shipper or a broker, they've got freight, they need it moved. We've got a carrier that wants to move freight. If we're just giving the two of them the ability to connect and negotiate and reach an agreement, then I don't think we're arranging. I don't think we're brokering. I think we're just a technology platform at that point. And I've said we're no different than the phone company when the shipper picks up the phone and calls the carrier and says, let's negotiate for you to move my freight. We're just providing the medium, the platform there. Now, if they go beyond that, and if they are involved in the negotiating of the rates, or they're involved in the selecting of the carriers, or they are taking a cut or a margin out of the agreed rates, then there's an argument that they are brokering. But if they're not negotiating, they're not taking a margin, they're not choosing which carrier gets that freight, then I think it's pretty clear they're not brokering.
And again, the name of the bill of lading would be in the trucker's name, and the shipper would be required to put that in. Double brokering is a problem here where one trucker shows up, gets loaded instead of the one that was assigned the load, and that becomes a problem that you have seen some cases there, have you not, Fred?
Yeah, that's this is where the load's been, brokered essentially twice, and a carrier that nobody really knows about shows up for the freight. That's where you typically see your hostage loads. The carrier gets the freight, they take it out, we don't know where they are, and they say, I need $5,000 more to deliver this load. I'm not going to deliver it unless you pay me $5,000. We also see the fraudulent, theft situations here of it gets brokered, it gets rebrokered. That the second broker is a fake broker. They take the freight charges and then they're gone. They, you never hear from them again. And meantime, the carrier's saying, well, I transported this and didn't get paid. The carrier's going to jump all the way over those brokers back to the original shipper and say, I'm suing you, shipper, for my freight charges. And if you're that first broker that got the load from the shipper's going to turn to you and say, you better pay these freight charges to this carrier. So even though you've already paid the fake broker. Big problems there.
So the key is you want to make a trucker tell our insurer to get it from the original person who arranged for the load, not from a second party involved in that. Again, follow the money. It's going to be case by case, and money is a big concern because the government is concerned about the money part. You mentioned safety, and you look at because they want to protect the smaller motor carrier who's not getting paid. So I think it boils down to that part. It doesn't. A lot of cases, Fred, it's the money part here. Then last, we've got a couple of minutes here. Just talk about the additional liability for a broker and their concern and what the negligent selection means, Fred.
Yes, so we all know that if we have a client that's a trucker and they cause an accident, they're going to get sued for that. But let's say this trucker brokered, interlined it, subcontracted it. We've used those terms, but they brokered it out to another carrier. Now they could be sued for choosing an unsafe carrier. So that's the big thing is, you picked a carrier that had bad safety rating and had a bad scores on SMS. They didn't, hire good drivers. I mean, it could be any number of things. They can always find something that they can say the carrier could have done better. And so you face that liability. And then the question is, do you have coverage for that? Do you have coverage for that liability? And we've talked about some of the issues with scheduled autos versus hired and non-owned. And, we'd have to look, because if you're brokering without authority, you're probably not going to have the broker contingencies, either the contingent auto or the truck broker liability coverages that are designed to protect in that situation.
So I'd like to just sum it up here is that particularly agents who are here, talk to your truckers, your smaller trucker particularly. Do not do this. If you accept the load, do not give it to another trucker. You got exposure for no coverage. You got exposure for civil authority. You got personal exposure. You got collection. You just can't do that. It's okay to say, I can cover it by sending a friend there and let your friend negotiate directly with the shipper, but not these others. And then second is if we get obviously opportunity to write the coverage for some of these outlying entities, dispatch service, be very leery of these things, because now as an agent you're going to be involved in some gray areas here, and you don't want to be in that part of it.
Yeah, and
Fred,
I'll add two quick points, Tommy, as kind of just pointers for agents. Number one is, add it to your checklist to ask your clients if they're doing this. Are you accepting loads that you then transport out? But also, even if they tell you that they're not, look on SMS at their inspections. And if you see a mismatch, if we've got someone who's got 2 trucks, 5 trucks, but they're transporting an incredibly high volume of freight, or they say that they've got a revenue that's up here, but their equipment to handle that revenue is like down here, we know they're taking loads that they're brokering out because they don't have the equipment to move all that freight. Okay, so check up on them and look at those things. And then the second thing is, if they're doing that and you have this talk with them and they say, well, I hear what you're saying, but I got to do what I got to do. It's the business world, and I've got to do this. Then let's get them broker authority. Have them. I work with a number of carriers. Tommy does too. That we help them set up a brokerage and get that authority. And with the bond now being 10 years of the increased bond, there's lots of good options out there to source that bond. So we can get them legal and take care of most of these situations for them if that's something you see going on.
Yeah, and also remind them that they do one of these dispatch services or designated agents and those things, they might have a problem collecting the money too with that double broker. That would be the fear. Fred, as always, we appreciate you and Rob and all the services your agency does, your law firm does for us and the foundation. Thank you for giving your time and your knowledge for the Motor Carriers Insurance Education Foundation. And for that, folks, we'll see you next month on the second Thursday of the next month. Appreciate it, Fred.
Great. Thank you, Tommy.